Okay, we're going to find out just what compulsory actually is. And because we all need to know. It's so unfortunate that we don't know enough about anything. Okay, we're going to find out just what compulsory actually is. And because we all need to know. Get over here and share the screen. They have all the ages, first of all. They go through the states, and we might as well just read those because everybody needs to understand, because this is just America. And it won't take that long.
State age of required school attendance, minimum age limit to which free education must be offered, maximum age limit to which free education must be offered. Alabama 6 to 17 5 17 2, Alaska 7 to 16 3 5 20, Arizona 6 to 16 4 6 21, Arkansas 5 to 18 5 21, California 5 6 to 18 5 21. Colorado 6 to 17 5 21, Connecticut 5 to 18 6 5 21, Delaware 5 to 16 5 21, District of Columbia 5 to 18 5 7 8, Florida 6 to 16 4, Georgia 6 to 16 5 19, Hawaii 5 to 18 5 20, Idaho 7 to 16 5 21, Illinois 6 to 17 4 21 9, Indiana 7 to 18 5 22. Iowa 6 to 16 10 5 21, Kansas 7 to 18 5 11, Kentucky 6 to 18 5 21, Louisiana 7 to 18 5 12 20 13, Maine 7 to 17 5 14 20, Maryland 5 to 18 5 21, Massachusetts 6 to 16 3 15 22, Michigan 6 to 18 5 20, Minnesota 7 to 17 5 21, Mississippi 6 to 17 5 21. Missouri 7 to 17 16 5 17 21, Montana 7 to 16 18 5 19, Nebraska 6 to 18 5 21, Nevada 7 to 18 5 21 19, New Hampshire 6 to 18 21, New Jersey 6 to 16 5 20, New Mexico 5 to 18 5, New York 6 to 16 25 21, North Carolina 7 to 16 5 21, North Dakota 7 to 16 5 21. Ohio 6 to 18 5 22, Oklahoma 5 to 18 5 21 21, Oregon 6 to 18 5 19 22, Pennsylvania 8 to 17 6 23 21 24, Rhode Island 5 to 18 25 5 21 26. South Carolina 5 to 17 5 22 27, South Dakota 6 to 18 28 5 21, Tennessee 6 to 18 5, Texas 6 to 19 5 26, Utah 6 to 18 5. Vermont 6 to 16 29 5, Virginia 5 to 18 5 20, Washington 8 to 18 5 21, West Virginia 6 to 17 5 22, Wisconsin 6 to 18 4 20, Wyoming 7 to 16 35 21. Not available. In this state, local education agencies determine their maximum or minimum age, or the information is not available in the statute. Not applicable. State has not set at a maximum age limit. 1, in Alabama, the parent or legal guardian of a 6-year-old child may opt out of enrolling their child by notifying the local Board of Education, in writing, that the child will not be in school until he or she is 7 years old. 2, in Alabama's city school systems, students are entitled to admission until age 19. 3, Alaska requires that students attend until they are 16 or complete 12th grade. 4, in Arizona, students must attend until they are 16 or complete 10th grade. 5, in California, no school district may receive school district appropriations for independent study by students 21 years of age or older, or by students 19 years of age or older who have not been continuously involved in kindergarten, or any of the 1st to 12th grades, inclusive since their 18th birthday. 6, in Connecticut, the parent of a 5 or 6-year-old child may opt out of enrolling their child until he or she is 7 by signing an option form. 7, District of Columbia, students who are at least 3 years old by September 30th are eligible for admission to the Preg 3 program. Students who are 4 years old by September 30th are eligible for the Preg 4 program. Students who are 5 years old by September 30th are eligible for kindergarten aid. An adult student who is a resident of the District of Columbia is eligible for free instruction in the schools, as long as the student meets all other criteria and prerequisites for admission. 9. In Illinois, re-enrollment is denied to any child 19 years of age or older who has dropped out of school and who cannot, because of age and lack of credits, attend classes during the normal school year and graduate before his or her 21st birthday. 10. In Iowa, children enrolled in preschool programs, 4 years old on or before September 15th, are considered to be of compulsory attendance. Age 11. Adults in Kansas have access to an education if they enroll in a public school. However, school districts are not required to provide educational services in a regular school setting to anyone who has reached 19 years of age and who is not currently enrolled in a school district. If a school district elects not to provide a person with educational services in a regular school setting, the district must offer the person educational services in an alternative setting or program. 12. Each Louisiana city and parish school board may provide for a child younger than 5 to enter kindergarten if that child has been identified as gifted by the state guidelines. 13. In Louisiana, admission must be granted to any student who is 19 years of age or younger on September 30th or 20 years old on September 30th and has sufficient course credits that he or she will be able to graduate within 1 school year of admission or readmission. 14. In Maine, students must be at least 5 years old before October 15th, or 4 years old by October 15th if they are enrolled in a public preschool program prior to kindergarten, where offered. 15. Each school committee in Massachusetts establishes its own minimum age for school attendance, provided that it is not older than mandatory minimum age established by the state. 16. Missouri requires attendance until 17 or the completion of 16 credits toward high school graduation. 17. A child between 5 and 7 years old in Missouri may be excused from attendance at school if a parent or guardian submits a written request. 18. In Montana, attendance is required until students are 16 or complete 8th grade. 19. In Nevada, students may attend a comprehensive public school until age 21, or, from age 18, they may attend an adult high school program. There is no upper age limit for adult high schools. 20. In New York, the boards of education in the Syracuse, New York City, Rochester, Utica, and Buffalo school districts are authorized to require children who are 5 years old on or before December 1st to attend kindergarten unless the parents elect not to enroll their child until the following September, or the child is enrolled in a non-public school or home instruction. New York local boards of education may require 16 and 17-year-old students who are not employed to attend school until the last day of the school year in which the student turns 17. 21. In Oklahoma, children who are at least 4 years old but not older than 5 on or before September 1st may attend either half-day or full-day programs in their district free of charge as long as the district has the physical facilities and teaching staff to accommodate the student. 22. In Oregon, a district may admit a student who has not yet turned 21 if he or she requires additional education to receive a diploma. 23. The Board of School Directors in any Pennsylvania school district may establish kindergarten programs for children between the ages of 4 and 6. 24. In Pennsylvania, a child who reaches age 21 during the school term and who has not graduated from high school may continue to attend the public schools in their district free of charge until the end of the school term. 25. In Rhode Island, the compulsory age is 16 if a student has an alternative learning plan for obtaining a high school diploma or its equivalent. 26. Although some Rhode Island districts allow students to complete the school year after they turn 21, this practice is not universal and not required. 27. In South Carolina, individuals older than 21 years old may attend night schools. 28. In South Dakota, the compulsory age limit is 16 if a child enrolls in a general education development test preparation program that is school-based or for which a school contracts, and the child successfully completes the test or reaches the age of 18. 29. Vermont requires students to attend school until they are 16 or complete 10th grade. 30. Wyoming requires students to attend school until they are 16 or complete 10th grade. Source: Education Commission of the States. Age requirements for free and compulsory education. Retrieved January 8, 2018 from https://www.x.org. Age requirements for free and compulsory education. Data source: Data tables. Table archive. IES and says National Center for Education Statistics explore the Institute of Education Sciences IES home about publications data funding news IES centers and C. CERN says home about.
Now we just have to understand, what does the word compulsory actually mean? That means we need to go surfing. Let's see. Compulsory. Go here. Go back here. Let's just see this one. What is it going to give us? No download available. Oh no. Let's see. No. Let's look at that one. No, thank you, feedback. Here we go. Which one do you want to see? Attendance loss or just education? I think we should listen to attendance loss first. Because it's in big capital stuff. No downloads available, of course. Let's go back up. That's enough. Start speaking.
The historic background of compulsory school attendance laws, their advantages and disadvantages, their effects on children's rights, and some possible alternatives to compulsory schooling are discussed. Abstract using published literature, case law, and state and federal legislation. The historical development of compulsory school attendance and child labor legislation is explored. The beginnings of the juvenile court and current problems related to compulsory schooling and the juvenile justice system also are examined. Historical information is used to interpret current problems and illustrate trends regarding the status of children through discussion of court decisions and concerns expressed in the literature studied. Issues related to children's rights regarding compulsory schooling are considered. Alternatives to compulsory schooling and correctional intervention with truants are presented, although there is still a great deal of confusion in the area of children's rights. Schools and courts are undergoing a change in response to the Constitution. With the expansion of children's rights in recent years, the following conclusions are made. Children, as well as adults, should have the right to determine the matters that affect them most directly. The coercive mechanisms of compulsory school attendance laws and juvenile justice system processing of truancy seem to violate fundamental rights, and an alternative appears to be creation of non-coercive learning experience without juvenile court jurisdiction over truant children. The findings point to the need for assessing the social, emotional, and economic consequences of the implementation of children's increased rights and consequent responsibility for the control of their own lives. A bibliography is included. RCB additional details. Corporate author Sam Houston, State University, address Huntsville, TX 77340. United States publication format, article publication type, historical overview, language English.
Now, let's just go back up and compulsory. EDUCA. Yeah, education, and we're gonna have to just find it because come on now. Is that the one? I read that one, so let's just, this is the one for youth for disabilities, because that changes the game, boo. This is the whole game changer with Joe Chillins and behavioral issues. And we select all the text, select, and then begin to speak.
Educational advocacy for youth with disabilities. The Individuals with Disabilities Education Act, IDEA, mandates that states provide a free and appropriate public education for all students with disabilities if the state receives federal support for educating students with disabilities. IDEA gives enforcement authority not only to the federal and state departments of education, but also to individuals. 38. Therefore, if a parent, youth advocate, or Department of Education worker finds that a detained or confined youth is not receiving adequate educational services, IDEA can be used to secure appropriate education for this youth. Previous studies emanating from litigation and professional literature in this area document the inadequate educational services received by youth in custody. 39. IDEA serves as an ideal tool to access educational services for youth with disabilities because it requires public schools and state-operated programs, such as juvenile correctional facilities, to provide each eligible child with adequate special education and related services. The Individuals with Disabilities Education Act. Although nearly all states have compulsory education laws and provide educational services through local school districts, Congress recognized the special needs of students with disabilities when it passed IDEA in 1975. IDEA mandates that all eligible students receive a free and appropriate education in the least restrictive setting possible. 40. Any state receiving federal funds for educating students with disabilities must take affirmative steps to identify and evaluate all students who they suspect are eligible for special education services. 41. The identification process used by the state or education program must be racially and culturally non-discriminatory. 42. Under IDEA, identification of any of the following disabilities entitles a student to free appropriate special education and related services: mental retardation, deafness, hearing impairment, speech or language impairment, visual impairment, serious emotional disturbance, orthopedic impairment, other health impairment, blindness, specific learning disability, autism, traumatic brain injury, or multiple disabilities. 43. Once a youth has been identified as eligible for special education and related services, an individualized education program, IEP, must be developed before services commence. 44. To ensure that each child's special needs are addressed, the IEP must be produced at a meeting with the student's teacher, parent, and a representative of the educational program. 45. The IEP must specifically identify the educational needs of the individual student, then provide a plan for meeting those needs. IDEA regulations outline the specific areas to be addressed in the IEP and discuss the student's level of functioning, long and short-term educational goals, and all related services that must be provided to help the child reach those goals. 46. The services may include individual tutoring, counseling, and any other educational assistance needed by the student. If the education program that is established for the child does not provide all of the services outlined in the IEP, then it has violated IDEA and the rights of the child with the disability. 47. In addition to securing adequate special education services, IDEA is a landmark statute because it gives parents of a child with disabilities, or a child suspected of having disabilities, the ability to monitor the assessment, identification, and education of the child through IDEA's grant of certain procedural and substantive rights. IDEA regulations require that parents be notified of and give permission for the initial evaluation of their child. 48. Once their child has been identified as being eligible for special education services, IDEA also gives parents the opportunity to contribute to decisions concerning the development of the IEP. If the parents find that the evaluation of their child or the implementation of the child's educational program is unsatisfactory, they can use the complaint and hearing procedures provided by IDEA. 49. Parents or advocates filing administrative complaints or invoking due process hearings trigger the primary mechanisms through which IDEA ensures delivery of mandated educational services. The scope and specificity of IDEA represent unprecedented federal involvement in state and local education by providing statutory educational guarantees to all children ages 5 to 21 with disabilities. 50. Since the passage of IDEA, parents and advocates no longer have to rely on constitutional due process or equal protection claims in order to secure educational opportunities for their children. When schools fail to provide appropriate services to children with disabilities, including schools and juvenile detention and correctional facilities, IDEA enables parents to file complaints or invoke hearings in order to access appropriate educational services. IDEA gives parents and advocates both the mechanisms to appeal the educational decisions of school districts and the opportunity to seek redress in court. Reauthorizations of IDEA have broadened the eligibility to children from 3 to 22 years of age in most states. In 1986, the passage of the Handicapped Children's Protection Act guaranteed reimbursement of attorneys' fees to parents who prevail in litigation brought under IDEA. 51. Recent reauthorizations have placed increased emphasis on the transition of youth from Special programs to the community. Transitional services may be especially important for youth in custody. Youth released from detention facilities need transitional services to reintegrate successfully into the community, and the special education system often has resources that the juvenile justice system does not. Future reauthorizations of IDEA may seek to limit the scope of the educational services provided and the eligibility of youth for these services. 52 advocates should make certain that their congressional representatives are aware of the importance of IDEA and the consequences of denying disabled students an appropriate education. Accessing special educational services can provide many detained and incarcerated youth with programs that enhance their abilities to reintegrate into the community and to succeed in their education. IDEA and juvenile justice. Although a few studies have attempted to determine the prevalence of disabilities among youth in correctional institutions, methodological problems and varying definitions of disabilities have made it difficult to come up with reliable figures. Completed studies have estimated that the percentage of detained and incarcerated youth with disabilities ranges from 42% of all juvenile offenders in Arizona to 60% of all juvenile offenders in Florida and Maine. 53. In an attempt to assemble cogent data, Casey and Keelitz conducted a meta-analysis of all of the predominant studies of disabled juvenile offenders. 54. They estimated that 35.6% of juvenile offenders have learning disabilities and an additional 12.6% have mental retardation. Casey and Keelitz also reported that they could not conduct a meta-analysis of youth in juvenile corrections with emotional disturbances due to insufficient quality and numbers of studies. A recent analysis of studies on the prevalence of mental disorders among youth in the juvenile justice system, however, estimates that approximately 22% of those incarcerated have significant mental health problems. 55. Whether 30%, 60%, or a higher percentage is a reliable estimate for the prevalence of disabilities among youth in juvenile corrections is beyond the focus of the current discussion. What we do know is that the percentage of youth in juvenile correctional facilities who were previously identified and served in special education programs prior to their incarceration is at least 3 to 5 times the percentage of the public school population identified as disabled. 56. With this proportion of detained and incarcerated youth entitled to special education, IDEA provides the vehicle to access these services. Litigation under IDEA. Prior to the passage of IDEA in 1975, many advocates initiated litigation to secure the right to education and related services for children with disabilities. In subsequent years, much of the litigation has sought to define and clarify the nature of that right. 57. While most cases involving claims under IDEA have been heard by U.S. district courts and U.S. circuit courts of appeal, a few cases have reached the U.S. Supreme Court. Among other things, the Supreme Court has addressed issues such as the meaning of appropriate education. 58. Whether specific services are medical or educational and are covered under IDEA. 59. The payment of attorney's fees and costs when parents prevail in disputes with local school districts concerning services. 60. Whether children with communicable diseases can be classified as disabled for educational purposes. 61. And disciplinary exclusion of students with emotional or behavioral disorders. 62. Although the provisions of IDEA have applied to all states receiving federal financial assistance under Part B of this legislation, many states have been slow to provide special education services to incarcerated youth with disabilities. 63. During the past few years, advocates have challenged the quality and availability of education for youth with disabilities in juvenile correctional facilities. Although many of these cases are currently being litigated, some suits have been settled. Advocates have used IDEA to litigate on behalf of incarcerated youth with disabilities in a number of states. Since 1975, more than 20 class action lawsuits involving special education services in juvenile corrections have been filed. With few exceptions, the cases that were initiated have never gone to trial, and very few published judicial opinions exist. Most often these suits have been settled through consent decrees or settlement agreements that responded to nearly all of the claims made by plaintiffs, typically after years of procedural delays. Table of cases. Table 1 displays cases involving special education claims in juvenile corrections litigation. All of the cases are class action lawsuits brought on behalf of residents in juvenile facilities who were entitled to special education services. The fact that 15 of the 25 cases listed were filed in the 1990s shows the heightened awareness of special education issues and the strength of IDEA. A quick review of the table reveals that the cases emanated from many different regions of the United States. clearly illustrating that the inadequacy of special education services in juvenile correctional facilities is a nationwide concern. Most of the complaints involved special education issues in isolation. However, a few have involved constitutional issues as well. The length of time between initial complaint and settlement ranged from about 2 to 7 years for those suits that have been closed. A review of 3 cases illustrates some of the problems associated with educational services in juvenile corrections. Andre H. v. Sobel. Andre H. v. Sobel, initiated in the U.S. District Court of the Southern District of New York in May 1984, was brought on behalf of juveniles eligible for special education services at New York City's Spofford Juvenile Detention Center. Plaintiffs' attorneys claimed that Spofford, a detention and holding facility, conducted no screening activities to identify youth who may have disabling conditions, convened no multidisciplinary team meetings to determine eligibility and plan appropriate educational services, and made no attempt to obtain records from schools previously attended by the youth. As a result of these and other practices, no special education services were provided to detained youth at Spofford. In January 1991, 7 years after the initiation of the suit, a stipulation and order of settlement was signed by attorneys for the plaintiffs and the defendants, the New York City Department of Juvenile Justice, and the New York City Board of Education. The settlement required Spofford to develop a multidisciplinary team at the detention center and fully implement the provisions of IDEA. The agreement also required that the parties jointly appoint a monitor who would visit the facility semi-annually for 3 years and determine the extent of compliance with the agreement. At the conclusion of the monitoring period, Spofford was found in compliance with the settlement agreement. Johnson v. Upchurch. In contrast to Andre H. v. Sobel, which focused only on special education, Johnson v. Upchurch addressed a broad range of issues in juvenile corrections. In 1986, Matthew Johnson, a youth confined to Catalina Mountain Juvenile Institution near Tucson, filed a complaint on his own behalf concerning his treatment at the juvenile correctional facility. A subsequent class action lawsuit filed in the U.S. District Court for the District of Arizona claimed that the Arizona Department of Corrections failed to provide special education services to youth in custody. Additionally, plaintiffs maintained that the conditions of confinement were unsanitary, hazardous, and punitive. In spring 1988, during a time when there were no special education services at the facility, the plaintiffs requested an injunction requiring the Arizona Department of Corrections to fill a vacant teaching position and provide appropriate services. The court subsequently appointed a special master to assist in the resolution of education complaints and to evaluate special education services. After protracted negotiations, Johnson v. Upchurch was settled in May 1993 through a consent decree that required broad reforms in juvenile corrections throughout the state of Arizona. The consent decree also specified that a committee of consultants should oversee and monitor the implementation of the Agreement 64 at the time of this writing. The Arizona Department of Juvenile Corrections is in compliance with all educational components and with most other provisions of the consent decree except population limitations. 65 Smith v. Wheaton. Smith v. Wheaton, filed in U.S. District Court for the District of Connecticut in 1987, has not been settled yet. Like Andre H. v. Sobel, the complaint in Smith v. Wheaton focused only on the educational needs of incarcerated youth with disabilities. Unlike the plaintiffs in Andre H. v. Sobel, those in Smith v. Wheaton were in a long-term facility rather than in temporary detention. The plaintiffs in Smith v. Wheaton complained that the Long Lane School, a juvenile correctional facility operated by the Connecticut Department of Children and Youth Services, failed to meet minimum timelines for evaluation of youth and for provision of special education services to those deemed eligible. Plaintiffs also alleged that parents were not involved in educational decision-making for their children with disabling conditions, that no related services such as counseling or occupational therapy were available, that Long Lane School failed to develop IEPs as required by IDEA, and that adequate transition plans were not developed for youth leaving the facility. Although plaintiffs and defendants in Smith v. Wheaton have engaged in settlement discussions during the past 5 years, as of this writing the case is unresolved. These 3 cases are somewhat representative of the litigation under IDEA and the problems associated with educational services in juvenile corrections in many jurisdictions. In each case, plaintiffs alleged violation of IDEA. In the 2 cases that were settled, The defendants responded by providing a level of educational service that met the requirements of the law and was comparable to services available in the public schools. Beyond the educational costs accrued from providing inadequate services or no services for a period of time, the defendants were required to pay the costs of the litigation. In Arizona, the state paid more than $1.8 million in plaintiffs' attorneys' fees and more than $180,000 to two named plaintiffs. The cost of private attorneys defending the state added to the total cost of this litigation. Implications: litigation raises a number of issues for administrators, policymakers, and advocates. First, litigation in several jurisdictions has been a tool, albeit an expensive one, used to reform juvenile correctional education programs. 66 In some instances, litigation has led to the establishment of special education services that did not previously exist in spite of the plain, inclusive language of federal statutes and corresponding state regulations. In Arizona, litigation enabled advocates to work with legislative leaders to create the Department of Youth Treatment and Rehabilitation, which separates juvenile corrections from the adult correctional system and creates a school board for the new department. Prior to the current reforms, the educational programs in Arizona's juvenile confinement facilities did not meet Arizona state guidelines for minimum amounts of instruction each week. Among other things, the Johnson v. Upchurch consent decree required the state to pay teachers in juvenile correctional facilities salaries comparable to those paid to their public school counterparts and to obtain North Central Association of Colleges and Secondary Schools accreditation for correctional facility schools in the state. A second and related litigation issue involves the role of state departments of education in providing oversight and consultation to juvenile correctional programs. While each Department of Education guarantees that all schools and state-operated programs will provide special education and related services to eligible youth as a condition for the receipt of federal funds, in reality, the U.S. Department of Education has never withheld any money from states that fail to provide appropriate special education services in juvenile corrections, until monitors at the U.S. Department of Education and their counterparts in state departments of education enforce their mandates to ensure that all youth with disabilities receive appropriate educational services. Advocates and parents appear to have no other recourse than litigation. Presumably, incarcerated youth with disabilities and their parents have the same due process protections in education as their public school counterparts. Any number of familial factors, the distance of youth from their home communities and schools, and the lack of administrative mechanisms in some juvenile justice systems make it unlikely that parents and their children will have access to those legal protections in the absence of oversight by state departments of education. A third issue raised by litigation involves the competing purposes of juvenile corrections. While rehabilitation is often cited as one of the purposes of juvenile corrections, incapacitation and punishment are frequently higher priorities. In many facilities and state agencies, the organization and administrative structure do not support rehabilitation as an outcome for juvenile clients. Limited fiscal resources often make education compete with security, maintenance of the physical plant, and new construction needs. In Arizona, for instance, prior to the reforms associated with Johnson v. Upchurch, other than for teachers' salaries, there was no annual budget for education. Educational program managers had to go hand in hand to the superintendent of their facility to obtain books, pencils, paper, and other consumable materials associated with operating a school. Alternatives to litigation. Although positive results can occur from litigation, this does not mean that litigation should be the primary use of IDEA. Rather, IDEA establishes a framework within which parents and advocates can present their special education concerns to correctional facilities in the interest of avoiding litigation. The mandates of IDEA require educational facilities to meet the special education needs of all students. Providing special education services to youth with disabilities in juvenile corrections facilities, however, is inextricably intertwined with the general quality of educational services for youth in custody. Educational services in juvenile corrections, whether operated by the Juvenile Corrections Agency, the State Department of Education, or a local school district, are typically a low priority for many correctional administrators. All educational programs in juvenile facilities must begin to meet the minimum standards associated with public schools in order to provide educational services for youth with disabilities. Under current arrangements, the infrastructures needed to support quality juvenile correctional education programs are missing in many jurisdictions. Correctional education programs, with some exceptions, do not have the autonomy, administrative structure, or fiscal resources necessary to provide quality education for incarcerated youth, much less to meet the needs of disabled youth. The nation's youth do not have a statutory or constitutional right to good or even adequate education. Some improvements arguably necessary under IDEA, however, can be used to improve the general level of schooling for all incarcerated youth. Strengthening educational programs and ensuring that eligible youth receive special education services require that correctional education programs develop stronger ties to public school programs, gain fiscal and administrative autonomy from the correctional agency, meet standards associated with public school programs, and implement the requirements of IDEA in their facilities. Stronger ties between public school programs and correctional programs could ameliorate the delay that occurs when correctional education programs try to obtain prior school records for their students. Correctional education programs often wait months to receive grades, test scores, IEPs, and other information that would help educators in juvenile corrections evaluate and place students and provide appropriate services. The information in school records routinely passed between public school districts is often delayed when the request for records originates in a correctional facility. Compounding matters is the fact that many incarcerated youth have had mobile school careers and in some instances have been truant or expelled from school for a period of time prior to their incarceration. Even in those states where special school districts for correctional education have been established, such as Connecticut and South Carolina, obtaining prior school records is still a problem. Creating stronger links between correctional programs and the public school system can be accomplished by having local school districts operate educational programs for juvenile corrections. In Florida, a local school district operates the educational program in the state's two secure confinement facilities for juveniles. At the very least, advocates could help convene meetings between juvenile corrections and state and local school representatives to agree on a method for efficient, mutual exchange of confidential school records of juveniles. Opening the channels of communication between public schools and correctional education programs is an important first step in providing an appropriate education in juvenile facilities. Strengthening correctional education programs also requires establishing administrative and fiscal autonomy that enables educational rather than institutional concerns to steer decisions about the use of resources, the assignment of staff, and the curriculum. Focusing on the educational needs of youth in facilities will not occur unless the administration of the correctional education program is autonomous. While educational administrators in juvenile correctional settings need to work cooperatively with institutional and agency administrators and staff, decisions about educational programs must be driven by professional standards, state guidelines for public school programs, and youth needs. In the absence of administrative and fiscal autonomy, educational administrators cannot develop long-range plans, infuse the curriculum with new instructional technology, or respond to the demands of the changing job market that youth will face. Fiscal autonomy can be achieved through establishing a cost per pupil that is set aside in the annual budget based on the average number of students residing or detained in the facility. Education should have an independent category in the correctional budget. Another means of ensuring fiscal autonomy is by contracting with local school districts for services and charging the correctional agency a minimum cost per pupil based on the average quarterly count of students in the correctional education program. Alternatively, juvenile corrections could assess average costs per pupil for each student and bill local school districts for the time that youth are in custody or confinement. While this remedy would certainly be unpopular with local education agencies, this arrangement, in addition to promoting the exchange of student information, would create incentives for local school districts to proactively serve those youth who are at risk for dropping out, failing school, and/or being suspended and expelled. Meeting professional education standards associated with public school programs can also enhance the development of more effective correctional education programs and appropriate educational services to youth with disabilities. The Correctional Education Association has developed and disseminated standards for correctional education programs in juvenile and adult facilities, but these standards are broad and have not been widely adopted. 67 Several correctional programs have sought accreditation from professional associations of schools and colleges, a promising avenue for improving services. Los Angeles County Court and Community Schools, serving more than 5,000 juveniles adjudicated in community-based and correctional facilities, achieved accreditation during the 1980s. The accreditation process has resulted in the creation of basic minimum standards for correctional school programs, including adequate space, an articulated curriculum, professional development, and adequate compensation for staff. Accreditation can help avoid costly litigation such as that which occurred in Arizona, which ultimately required accreditation of the educational program in each of the 3 secure facilities operated by the Arizona Department of Juvenile Corrections, improving correctional education programs by meeting professional standards, creating stronger ties to public schools, and gaining administrative and fiscal autonomy can lead the way to implementing the requirements of IDEA. Administrators, educators, and advocates would be prompted to be more attuned to the needs of the high percentage of disabled students in juvenile facilities. Once the local school provides the students record, youth with previously diagnosed disabilities can receive appropriate services. Those students who have not been identified as disabled, but appear to have difficulties, can be evaluated for undiagnosed disabilities. Advocates should encourage correctional schools to use IDEA for accessing the resources to offer services to juveniles with disabilities. The federal funding available under IDEA provides a major incentive for facilities to identify and maintain services for disabled youth in detention and correctional facilities. Conclusion: youth with disabilities have specific rights to educational services. IDEA mandates that the special education needs of all youth be met, including youth in custody. In light of the overrepresentation of youth with disabilities in juvenile corrections, recent class action litigation with educational claims for juveniles with disabilities offers hope for improving special education services. The implications of litigation and alternative ways to improve educational programs in facilities for juveniles also support the notion that appropriate special education services can be provided to youth in custody. The record suggests that advocates for incarcerated youth can be successful in using IDEA to obtain appropriate educational services. Class action lawsuits are one means of obtaining services and improving the conditions of confinement for youth in juvenile corrections. Parents, guardians, advocates, and others concerned about the educational welfare of incarcerated youth can also press correctional institutions for appropriate services for youth on an individual basis. This process can begin with a careful examination of a youth's prior school history, a record of school failure, unexcused absences, chronic disciplinary problems, and grade retention may be associated with a disabling condition that has not been detected. Vision or auditory problems, learning disabilities, and emotional disorders can contribute to poor school performance and school failure. Family mobility, other family concerns, and economic instability can also result in serious learning problems being overlooked by the schools. A parent, guardian, or advocate who suspects that a disability may be contributing to the poor educational performance of a child or adolescent should make a referral for an evaluation. The Juvenile Law Clinic at the District of Columbia Law School runs an education advocacy project that attempts to assist juveniles in delinquency proceedings by training law students and local attorneys to use special education law proactively and to suggest special education alternatives to confinement. 68 educational programs in juvenile corrections facilities should promote the academic and social competence of their students and ensure that they re-enter their communities better prepared to assume roles as students, workers, and citizens. IDEA is one vehicle that ensures that educational programs for detained and committed youth meet the needs of incarcerated juveniles. Checklist for using IDEA: if you have knowledge of a youth in custody who has disabilities and is not receiving appropriate educational services, you can verify if the youth has been identified as having a disability either before or after incarceration. Find out about the status of the youth's IEP if the youth has been identified as having a disability. Monitor signs of a disability by a youth who has not been identified as disabled and share your findings with an authority who has the ability to do an initial screening and obtain a more thorough evaluation. Discuss the need for appropriate services at the facility with teachers and tutors at the facility, a facility administrator, a special education attorney in the area or a law school clinical program, a professor of education, parents. Obtain the Correctional Education Association standards on correctional education programs. Review the facility's educational standards. Establish a committee of educators, advocates, and administrators to ensure that IEPs are conducted in a timely fashion by qualified personnel. Revise the educational standards of the facility. Simplify the eligibility determination for special education services. Ensure that the facility has qualified teachers, Involve local advocacy groups that support children and persons with disabilities. Contact an attorney who can assist you in bringing litigation against the facility if education services do not improve. Previous contents. Next.
Hmm.
Protection and advocacy systems in juvenile corrections. Another underutilized resource for improving the services received by disabled youth in detention and correctional facilities is the protection and advocacy (P&A) systems. P&As are federally funded and administered by the states, designed to provide legal assistance and advocacy on behalf of persons with disabilities. P&As render a variety of services, including information and referral, training and education, negotiations, legal services, investigation, and monitoring. However, P&As spend the vast majority of their time and resources on direct client representation. P&As exist in all 50 states and the territories through federal grants. Each of the three main federal programs in the P&A system targets a specific client group. First, Congress established the Protection and Advocacy System for Persons with Developmental Disabilities, PAD, as part of the Developmental Disabilities Assistance and Bill of Rights Act of 1975, DD Act, 69. The DD Act conditioned a state's receipt of federal funds under the program on the existence of a system to protect and advocate the rights of individuals with developmental disabilities. 70. Next, using PAD as a model, Congress established the Protection and Advocacy System for Individuals with Mental Illness, PAMI, in 1986. 71. The U.S. Department of Health and Human Services administers both PAD and PAMI. Finally, the Protection and Advocacy System for Individual Rights, PAIR, was created as a catch-all program for individuals with severe or other disabilities who are not eligible for services under either PAD or PAMI. 72. The Rehabilitation Services Administration of the U.S. Department of Education administers PAIR because the program was enacted as part of the Rehabilitation Act. Each P&A has the authority to pursue legal, administrative, and other remedies on behalf of its clients, provide information and referral services to residential and non-residential programs. 73. Investigate abuse or neglect of its clients. 74. Educate policymakers on decisions relevant to advocacy clientele. 75. And have access to clients and their records. P&As can offer assistance to incarcerated juveniles with disabilities when their disability-related rights have been violated or unmet. Disabilities are often ignored or mishandled within the delinquency context when, in fact, the cause of delinquent behavior may be directly related to a child's disability. Special education issues for persons with disabilities represent the largest category of cases handled by P&As, and some of this litigation is on behalf of incarcerated juveniles. 76. P&As also represent children with mental health problems, including those youth who reside in juvenile correctional institutions. Some P&As act as advocates for juveniles during the dispositional phase of a delinquency or abuse-neglect proceeding and make recommendations to the court about appropriate placements. A fourth grant-funded program called the Client Assistance Program, CAP, provides information and assistance to individuals seeking or receiving services under the Rehabilitation Act. 77. This chapter will not focus on CAP because of CAP's limited scope, applicability, and various restrictions, such as its prohibition against class action lawsuits. P&As may be used to help those incarcerated juveniles who fall within the client base of the P&A system and who need assistance with services related to disabilities. 78. While the P&A statutes do not establish one central agency to supervise and control the state systems, the National Association of Protection and Advocacy Systems, Inc., exists as a voluntary membership organization to provide training, technical support, and legislative advocacy for its members and consumers. 79. The statutory programs collectively, P&As, provide the largest source of legally based advocacy for persons with disabilities in the United States. 80. Following the principles that persons with disabilities are equal citizens under the law and that they are entitled to the same opportunities as all members of society, the P&A's strength lies in their ability to ensure enforcement of rights under the existing statutory entitlement programs. See Table 2 below. Table 2. Summary of the statutory programs. The statutory programs enacting statute clientele served administering agency funding PAD protection and advocacy system for persons with developmental disabilities Assistance and Bill of Rights Act of 1975 persons with developmental disabilities that fall within the statutory definition U.S. Department of Health and Human Services appropriations through the Developmental Disabilities Assistance and Bill of Rights Act of 1975 PAMI Protection and Advocacy System for Individuals with Mental Illness, Protection and Advocacy for Mentally Ill Individuals Act of 1986 persons with a mental illness who fall within the statutory definition U.S. Department of Health and Human Services appropriations through PAMI, but designated for PAD systems to carry out PAIR protection and advocacy system of Individual Rights Rehabilitation Act amendments of 1978 persons with disabilities who are not eligible under either PAD or PAMI rehabilitation services. Administration of the U.S. Department of Education appropriations through the Rehabilitation Act. PAD. The DD Act serves two major purposes. First, it sets out a Bill of Rights for the developmentally disabled. 81 Many of these rights are directly relevant to incarcerated individuals, such as the right to appropriate treatment and rehabilitation services, the right to receive those services in the least restrictive environment, the right to programs that maximize the individual's developmental potential, the right of those in residential treatment to be in facilities that meet their needs, and the right of residents to receive humane and sanitary care. The U.S. Supreme Court held in Pennhurst State School and Hospital v. Halderman that this listing of rights bestows no substantive, enforceable right on individuals with developmental disabilities. 82 These rights, therefore, cannot be asserted through litigation. This Bill of Rights can be used, however, as persuasive authority in advocating for a client and arguing that certain services should be provided in a specific way. Second, the DD Act provides funding. It offers financial assistance for states to carry out programs designed to improve services and assistance to individuals with developmental disabilities, and it funds a comprehensive nationwide network of protection and advocacy organizations. 83 states receiving funding under the DD Act are required to establish an agency or office responsible for assisting and protecting individuals with developmental disabilities. 84 The availability of this funding for advocates for the developmentally disabled encourages states to provide services in line with the Bill of Rights set out in the DD Act. The federal law requires that the state P&A agency or office be independent of public and private service providers in the state. 85 The DD Act requires this in anticipation of the tension between P&As and states or agencies that often provide inadequate or inaccessible services. The P&As must also have certain powers to carry out their mandate to protect and advocate for their clients. 86 Congress requires that each year the P&As develop a statement of objectives and priorities to guide their activities. Each P&A must select a governing board to oversee its activities that includes, in part, individuals with developmental disabilities who are eligible for services or who have received services, family members, guardians, or advocates. 87 PAMI Unlike the other P&A systems, PAMI was not established as part of a broader act but was the result of a specific piece of legislation, the Protection and Advocacy for Mentally Ill Individuals Act of 1986, MI Act. 88 This act provided exclusively for the creation of a P&A system to serve only institutionalized or formerly institutionalized individuals with mental illness. 89 However, the statutory scheme merged PAMI into the existing P&A systems by designating only PAD systems as eligible for funding under the MI Act. 90 Although PAD served as the basic model for PAMI, there are some differences between the two statutes. Both programs have narrow definitions of the clientele eligible for services. The DD Act's definition of developmental disability categorizes many people as either underqualified or overqualified to receive services. 91 Similarly, PAMI clients must have a significant mental illness that has been diagnosed by a state-licensed mental health professional. 92 While PAD serves any individual who satisfies the definition, regardless of his or her living situation, the MI Act's mandate is further limited to residents, or those discharged within the past 90 days, of a care or treatment facility. 93 The MI Act statutory definition says that facilities need not be limited to those listed and specifically includes jails and prisons. 94 Presumably, juvenile detention and correctional facilities are included in this language. PAIR The PAIR program was Congress' response to the gap left by the narrow clientele definitions of PAD and PAMI. The program was originally enacted under the Rehabilitation Act amendments of 1978 as a discretionary program. 95 pair lay dormant for 10 years because no funds were appropriated each year since 1989. However, some money has been designated for the program. In 1992, Congress amended the PAIR program to cover all individuals with disabilities not eligible for services under any of the other P&A programs. 96 in its current version. The PAIR program is similar in form and content to the PAD and PAMI programs. A survey of the P&A systems. To learn more about the P&A systems, the ABA Juvenile Justice Center conducted an informal survey of P&A providers and asked questions about ways in which their services could be applied to incarcerated juveniles. The survey confirmed that the P&A system can be an effective mechanism to oversee the provision of services to disabled youth in custody. Although P&As are federally funded, each state is responsible for establishing its own P&A system. The structure and functions of the systems vary from state to state. Within the requirements of the statutes, the P&A systems have the discretion to design programs that reflect their own needs and resources. Some generalizations, however, can be made about the structures of the P&A systems in many states. 97 currently, all P&As are eligible for funding under all three P&A programs. Most of the states have designated private nonprofit groups to serve as the P&A service provider, but some have designated state agencies. In New York, for example, the State Commission on Quality of Care for the Mentally Disabled, created in 1978, has been the P&A since 1980 when it replaced a private agency that had performed unsatisfactorily. The commission contracts out for services with different agencies in the state. Most states have private agencies, frequently legal services agencies, that serve as the P&A provider. Most P&As receive a blend of federal, state, and foundation funding. P&A staff generally consist of attorneys and advocates with experience in disability issues from diverse backgrounds such as social work, special education, nursing, public health, and administration. Advocates can be very helpful in non-litigious approaches to problem solving and are often very knowledgeable about available resources. The division of responsibilities between attorneys and advocates is different from state to state. In New Jersey, all cases are co-signed to an attorney and an advocate, but attorneys have to review and sign off on all case resolutions. Virginia has a similar system, with attorneys assuming primary responsibility for all administrative hearings and litigation. In California, attorneys handle all kinds of legal representation, from formal negotiations to class action lawsuits, while advocates handle less formal proceedings, such as interviews and investigations. Attorneys in Wisconsin have primary responsibility for litigation and supervision, and advocates handle negotiations, investigations, and monitoring. Nevada employs no legal staff and contracts out for all of its legal services. Maryland, with a total of 18 staff members in 3 offices, has a legal staff consisting of approximately 7 attorneys, who undertake more litigation than most other P&As. Often, states have only 1 attorney. Many states reported that much of their client representation involves administrative hearings in the areas of special education, Social Security benefits, Medicaid, and claims under the Americans with Disabilities Act. Several states noted that special education claims constitute the largest percentage of their caseload. In New Hampshire, as much as 30% of the cases involve special education issues with children. South Carolina considers children's issues, mostly special education, to be a priority. Litigation in individual cases, rather than class action lawsuits, is sometimes a last resort and may be seen as an unwise use of precious resources. P&As utilize litigation primarily for impact litigation, or class action lawsuits. A majority of class action lawsuits filed by P&As concern large-scale institutional violations. In 2 states surveyed, the P&As joined forces with private law firms to bring major institutional litigation on behalf of juveniles. The South Carolina P&A has teamed up with a large law firm and a civil rights attorney on a conditions of confinement case. 98 in New Hampshire, the P&A represented a subclass of disabled juveniles in an action involving all juveniles placed by the juvenile courts. 99 These are the type of partnerships that advocates for juveniles should be aware of. A resource rich partner teaming up with a P&A can make all the difference in litigation. Another area of emphasis, particularly on the PAMI side of the system, is investigation and monitoring of abuse and neglect in residential care and treatment facilities. In Wisconsin, the P&A PAMI component has 2 priorities. 1. Reducing institutional abuse and neglect, particularly through the use of seclusion and restraints, and 2. Advocating for the release of clients from institutions to less restrictive settings. To carry out these priorities, the P&A engages in much investigative and monitoring work. While the statute provides that all P&As must have authority to investigate and monitor, some P&As have had to sue just to gain access to clients and their records. If an investigation reveals serious rights violations, P&As usually prepare a report of their findings, present them to the responsible officials, and recommend remedial action. Some states also issue reports to the public to raise awareness and garner support. P&As attempt to work with the institution initially, both to avoid costly litigation and to foster cooperation. If the institution does not take appropriate action, sanctions may result. Most P&As report that investigations rarely escalate to litigation because of limited resources and the costs of litigation. When individual damages actions based on abuse or neglect claims arise, P&As usually refer these cases to private attorneys. In addition to the detained and committed juveniles in correctional facilities with identified disabilities, many juveniles who would otherwise be eligible for services have disabilities that remain unidentified. According to the South Carolina P&A, psychological studies have shown that disabilities in children worsen in juvenile correctional facilities. P&A staff are concerned that mental health problems, particularly depression and suicidal tendencies, are exacerbated during an extended period of confinement. Similarly, issues related to seclusion, restraints, treatment, discharge planning, and transition services are potentially ripe for advocacy by a P&A, using the P&A system to improve conditions for juveniles with disabilities. A defense lawyer representing a delinquent youth found him increasingly quiet, tearful, and isolated from other juveniles during his weeks in detention. The lawyer called the mental health unit at the institution where his client was committed to say that, in his opinion, what initially seemed to be a bad case of homesickness might be serious depression. A psychiatric evaluation was arranged and antidepressant medication prescribed. The youth's mother called the attorney to say that her son seemed worse on the medication, that other juveniles were taunting him, and that he was hearing voices. Institutional staff were getting impatient with the boy's refusal to get out of bed and his unwillingness to shower. The lawyer and mother met with the P&A lawyer. Although this P&A lawyer had not previously assisted an incarcerated juvenile, the lawyer was able to move quickly to arrange an evaluation in the mental health system. The P&A lawyer was able to have this youth treated for major depression in a short-term inpatient unit and released to a day treatment program with close supervision by a community-based delinquency project. Different medication controlled his psychotic symptoms. The P&A lawyer also assisted the boy's mother in setting up an IEP meeting so that her son's special education needs would be met while he was in the day treatment program and when he moved back to his junior high school. The P&A lawyer, meanwhile, had become aware of the great number of incarcerated youth with serious mental health problems. He also learned that many youth deteriorate emotionally as a result of the conditions under which they are confined, particularly when they are locked in their own rooms or in an isolation cell. The lawyer worked to devise the following two-part strategy. Parents and institutional staff were encouraged to call the local P&A to request assistance in arranging mental health services for incarcerated youth with disabilities. The P&A began a series of meetings to enhance the mental health treatment in the juvenile institution. The P&A pointed out that the staff psychologists and psychiatrists spent most of their time conducting court-ordered evaluations, which did not lead to needed services in the institution. The court agreed to ask another mental health agency to conduct many of these evaluations so some of the clinicians' time could be available to treat emotionally disturbed incarcerated youth. Using a P&A as an ongoing system of oversight of juvenile programs in a state can shed enough light on service deficiencies so that litigation can often be avoided. Advocates in each state can access the existing P&A system to help monitor the services received by youth in custody. P&As have the authority to investigate abuses, access records, and pursue administrative remedies on behalf of persons with disabilities. The P&A system in each state can help ensure that the rights of disabled youth in custody are not violated. Conclusion: seeking assistance from a P&A requires defining problems or issues so that they fit within the P&A's area of authority. Given the paucity of their resources, advocates must be ready to promote issues or potential clients to the P&A. Furthermore, advocates should examine what type of help is most needed from the P&A. Even if a P&A cannot seize the area of concern, it may be able to assist with problem solving. Not all incarcerated youth fit the narrow definition of disabilities under PAD, PAMI, or PAIR, but for those who do, P&As can be valuable resources in individual cases and can help obtain services systemically without litigation. On behalf of a distinct and disadvantaged client group, P&As act as individual and group advocates and monitors as they pursue remedies to institutional abuses. Incarcerated juveniles can fit into this scheme. Advocates for juveniles must be creative and should contemplate using the current P&A system in their state to access evaluations and services for young offenders with disabilities. Checklist for using P&As: if you know of a juvenile in a detention or correctional facility who has disabilities and is not receiving appropriate care or services, you should contact your state P&A office, see listing in Appendix G, and convince the office that this youth needs its help and will benefit from its advocacy services. Determine which statute applies to the juvenile by seeing if the juvenile's disability falls within the statutory definition for developmental disability. If it does, then PAD applies. Looking at whether the juvenile has a mental disability that qualifies him or her for assistance under PAMI. Determining whether the juvenile has a severe disability that is not covered by the two other programs, thereby qualifying him or her under PAIR. Inform parents, advocates, lawyers, and young people that P&As can assist them with accessing appropriate services for detaining and confined youth with disabilities. Previous contents. Next.
Mhm. This is very interesting. We have to go one more time.
The Administrative Procedure Act in Juvenile Corrections. Federal and state administrative procedure statutes can serve as a means to raise safe and lawful conditions of confinement issues for detained and incarcerated youth. The Federal Administrative Procedure Act, APA, and corresponding state administrative procedure statutes set out the process that agencies must adhere to both when making broad policy decisions, rulemaking, and when applying those policies to individual circumstances. Adjudicating. Administrative procedure statutes regulate executive agency behavior through the rulemaking and adjudication processes. Executive agencies include agencies involved with administering detention and correctional facilities, among other juvenile justice services. These administrative procedure statutes can be effective tools to address unjust procedures within facilities for juveniles. The breadth of administrative procedure statutes allows parties affected by the procedures of an institution to intervene when an institution makes rules or adjudicates. Juvenile justice institutions are replete with instances of rulemaking and adjudication. Each disciplinary code, behavioral regulation, and process for determining privileges and violations is a rule. The application of each of these rules to an individual's particular circumstances is an adjudication. Therefore, in some instances, administrative procedure statutes may allow for substantial oversight of institutional activities in states where statutes have been enacted. About 2/3 of the states have implemented administrative procedure statutes to govern state agency conduct. More than half of the states consulted and followed the Model State Administrative Procedure Act, Model State APA, when constructing their statutes. The other states modeled their statutes after the federal APA. Since the Model State APA and the federal APA differ, advocates must examine the specific provisions of their state statutes carefully. Distinction between rulemaking and adjudication. Notwithstanding the specific differences in each state's statutes, all statutes distinguish between rulemaking and adjudication procedures because these have different effects upon the rights of individuals. 100. To satisfy due process concerns, an action determined to be rulemaking must allow for public participation in the formulation of the rule. Alternatively, an action determined to be an adjudication entitles an individual to some level of hearing. Public participation in rulemaking helps to keep the political process of making rules in check. In a juvenile correctional facility, for example, there may be a desire to implement a specific mental health plan. Implementing a mental health plan is a broad policy decision because factors such as budget, space, personnel, and the number of youth are general to the entire facility population. The creation of this plan would be considered rulemaking. The required public participation in the process of creating the mental health plan will protect the residents' rights. Applying the mental health plan to an individual resident, however, is an adjudication. If the mental health plan, for example, requires that any youth who attempt suicide be placed in isolation, then the application of that rule to an individual compels some level of hearing. The level of hearings varies from formal to informal and depends on the applicable administrative procedure statute, constitutional due process, and facility regulations and practices. When applying administrative procedure statutes to juvenile correctional systems, it is important to determine whether the agency is acting in its rulemaking or adjudicatory capacity. The distinction between the two is based on the nature of the decision facing the agency. Actions pursuant to generalized facts do not require an individual hearing and can be taken according to procedures applicable to rulemaking. Actions pursuant to individualized facts require some level of hearing and are classified as an adjudication. The classification of the action as rulemaking or adjudication provides the basis for what procedures the agency must follow. Rulemaking. Under the federal APA, rules are defined as the whole or part of an agency's statement of general or particular applicability and future effect designed to implement, interpret, or prescribe law or policy. 101 Rulemaking is defined as the agency process for formulating, amending, or repealing a rule. 102 An agency action pursuant to common or generalized facts and applicable to a group of persons is termed rulemaking and must be carried out in accordance with statutory regulations. All agencies subject to the authority of an APA must follow its specific rulemaking procedures. 103 In theory, these procedures allow advocates to intervene in the rulemaking process before the rules become effective. For example, a juvenile justice agency may want to implement a rule that it will not allow youth, family members, or attorneys to participate in the placement decision. The agency wants to allow only a social worker's report on the youth, a treatment team summary, and a written statement by the youth to be considered. The agency may only implement the proposed rule following proper procedures. The agency must provide proper notice, allow for comment by all interested parties, consider all points of view, issue a concise general statement about the basis and purpose of the rule, and publish it at least 30 days in advance. Thus, during the notice and comment period, advocates can provide arguments and documentation demonstrating that both the facility and the youth would be better served by a rule that allowed for full participation by the youth and others in the placement decision process. Through this effort, advocates can stop the implementation of proposed rules or at least gather support to have them publicized or modified before they are enacted. Under both the federal APA and the model state APA, basic rulemaking procedures include publishing notice of the proposed rule in the Federal Register 104 under the federal APA or a state publication under the model state APA. The notice must contain statement of time, place, and nature of public rulemaking procedures, reference to the legal authority under which the rule is proposed, either the terms or the substance of the proposed rule or a description of the subjects and issues involved. 105 The agency must give interested persons the opportunity to participate in the rulemaking through the submission of data, views, arguments, and positions, with or without the opportunity for oral presentation. 106 Although this does not assure oral participation, a statute or regulation may guarantee a right to oral participation. All relevant matters must be considered. The agency shall promulgate rules with a concise general statement of their basis and purpose. 107. The rule must then be published at least 30 days before it becomes effective. 108. Rulemaking differences between the model state APA and the federal APA. The 1981 model state APA differs somewhat from the federal APA. One significant difference is the way in which each defines a rule. Under the federal APA, a rule can have general or particular applicability. The 1981 model state APA requires that a rule have only general applicability. 109 Therefore, under the 1981 model state APA, an action applicable to a group, but affecting only an individual, would be an adjudication and would require a hearing. The same action, however, would be considered rulemaking under the federal APA and would only require adequate public participation in the process. For example, a rule that affects all residents with learning disabilities where only one resident has a learning disability would entitle that resident to a hearing under the model state APA. Under the federal APA, the action would still be considered rulemaking and the resident would be entitled to intervene only as permitted through the rulemaking process. Another difference that exists between the model state APA and the federal APA is the amount of alteration permitted between the proposed rule and the adopted rule. Under the 1981 model state APA, the adopted rule may not be substantially different from the proposed rule. 110 under the federal APA, as long as the adopted rule is a logical outgrowth of the proposed rule, the adopted rule has been properly promulgated. 111 The model state APA allows for less alteration of a rule during the rulemaking process than the federal APA. However, the basic procedures for rulemaking under the model state APA and the federal APA remain fundamentally similar and provide advocates with an opportunity to intervene in the rulemaking process within agencies that run juvenile detention and correctional facilities. 112. Adjudication. The application of rules to an individual's particular circumstances results in the issuance of orders. The process for issuing an order is an adjudication. 113 An order is defined under the federal APA as the whole or part of a final disposition, whether affirmative, negative, injunctive, or declaratory, in form, of an agency in a matter other than rulemaking but including licensing. 114. Adjudications require some level of hearing ranging from formal proceedings to informal proceedings. These hearings may even be held before an administrative law judge. Formal hearings afford an individual certain rights, which may include the right to have counsel present, the right to cross-examine witnesses, the right to present evidence, and the right to a record of the proceedings. Informal proceedings may merely provide the opportunity to be heard and the right to a written explanation of the fact finder's decision. The formality of a hearing depends upon the requirements of the Due Process Clause of the Constitution, or a statute, or an agency's regulations or practice. Hearings, however, are not automatic, and unless the affected individual asserts the right to a hearing, the right may be waived. If an individual's constitutionally protected property or liberty interest will be affected by the adjudication, then the formality of the hearing depends on a due process analysis. This analysis balances the individual's property or liberty interest against the state's interest in restricting that property or liberty interest. The type of hearing required depends on the three factors outlined by the Supreme Court in Matthews v. Eldridge 115. The nature of the private interest affected, the risk to that interest posed by the challenged procedure and the likelihood that a different procedure would better protect that interest, the burden upon the government in imposing a different procedure. This balancing test yields the appropriate level of protection that should be afforded an individual before a property or liberty interest may be infringed upon in an adjudication. In one case, for example, an administrator wanted to transfer an incarcerated juvenile from a juvenile correctional facility to a mental hospital. Because this is an action applicable to an individual, it is an adjudication and requires some level of hearing. Treatment and social consequences in admission to a hospital are much different than in placement in a juvenile facility, and the transfer would therefore affect the juvenile's liberty interest. The Matthews v. Eldridge balancing test was applied to determine the appropriate level of hearing. The liberty interest of the juvenile and the risk imposed on that interest were weighed against the government's interest in the transfer. It was determined that a formal trial-type hearing needed to be held before the transfer could be made because admission to a mental institution posed a substantial risk to the liberty interests of the juvenile. 116. If an individual's statutory rights will be affected by an adjudication, the type of hearing will depend on the statute and APA in question. The model state APA requires a formal hearing in every case of adjudication, whether or not a statute expressly requires it. 117 The formal hearing protection of the model state APA applies to every adjudication. The federal APA takes a different approach to determining the level of hearing necessary. The protection of the federal APA applies in every case of adjudication required by statute to be determined on the record after opportunity for agency hearing. 118 This means that the federal APA's formal protections apply to hearings required to be on the record by a statute. A statute merely requiring a hearing, or one that does not speak to the matter, does not trigger the federal APA requirement of a formal hearing. 119 When a statute does not call for a hearing on the record, it is termed an informal adjudication. Informal hearings only occur under the federal APA. The federal APA requires very few procedural protections for informal adjudications. It does provide for the right to appear personally before an agency and to be represented by counsel. 120. It provides that subpoenas and reports be enforced only as authorized by law. 121. It also provides that the agency must give prompt notice and explanation of its decision. 122. Without these protections, agencies have substantial discretion over how to structure informal adjudications. Jurisdictions that follow the federal APA have fewer formal hearings than those that follow the model state APA. 123. This significant difference can be easily illustrated. After a youth threatened a staff member at an institution, the administration placed her in administrative segregation. The applicable Administrative Procedure Statute called for a hearing before she could be segregated. The resident and staff were questioned and the administrator found that the resident had made the threats, but no formal hearing was conducted. Under the model state APA, the resident was entitled to a hearing that met formal procedures because every adjudication requires a formal hearing. 124. Because the institution did not conduct a formal hearing and was in the model state APA jurisdiction, the resident had to be released from segregation, and a formal hearing had to be held. Under the federal APA, however, the resident did not have a right to a more formal hearing because the statute did not call for a hearing on the record. The agency's regulations or past practices could also have required more substantial protections under the federal APA. Agency regulations or past practices can trigger formal protections similar to those of the APAs. If an agency regulation provides certain procedural formalities for a hearing, the agency is bound to follow those formalities in the case of every adjudication. An agency cannot arbitrarily choose which protections to provide for hearings if its own regulations call for specific procedures. Also, if an agency has established certain procedures for particular hearings, that agency may be bound to apply those procedures to every similar hearing. An agency may be required, based on established practice, to apply certain procedures and formalities to particular hearings. Suppose a delinquent committed to an agency is eligible for release. Because problems exist between the youth and superintendent, the superintendent wants to deny the request. Neither due process nor the applicable Administrative Procedure Statute requires a hearing for the juvenile. The agency regulation, however, requires that a youth's treatment team and social worker issue reports taking a position on release. If the reports favor the release, a formal hearing is required before the youth can be denied release. An advocate may request the release reports from the treatment team and social worker. If the reports favor release, the youth must be released or a formal hearing must be held. The agency is bound to follow its own regulations, and the superintendent cannot circumvent these regulations in individual cases. In juvenile corrections, decisions are often made at the discretion of an administrator or staff member. If a staff member was required to follow specific procedures but failed to do so, although his or her discretionary decision cannot be challenged, the procedures for reaching the decision may be challenged. Suppose a staff member decides to punish a youth by requiring her to clean the unit's bathroom for a week. If the disciplinary code requires a hearing before any punishment greater than a reprimand may be imposed, the Administrative Procedure Statute can be used to invalidate the staff member's discretionary decision because the action was an adjudication without a hearing. In this way, the statute limits the discretion that individual juvenile corrections staff members may exercise. Of course, after a hearing, the youth may be ordered to clean the bathroom, yet that juvenile will have had the protections of a hearing, such as notice of the alleged violations and an opportunity to respond, before the increased sanction is imposed. Using the Administrative Procedure Acts to improve conditions of confinement, APAs can play a significant role in juvenile corrections reform because they govern the actions of the agencies charged with the administration of juvenile detention and correctional facilities, unless accepted by a specific statute. When these agencies promulgate rules, issue orders, implement programs, or deliver services, they must follow the procedures outlined in the state administrative procedure statutes. These procedures are intended to limit the discretion of the agency and provide for a fair use of the agency's power. The state statutes can be used by juvenile advocates in a variety of different ways. The statutes suggest that an agency provide a youth with a hearing when the agency makes decisions about that particular youth. Although a hearing may be provided for by statute, it must be demanded or an agency may deem it waived and then make important decisions without any input from the youth. The state statutes also provide procedural protections for hearings. This prevents the agency from arbitrarily deciding the procedures to apply at a hearing. If an advocate observes unlawful or inhumane conditions of confinement and wants to use an APA to improve the care of juveniles adjudicated delinquent, the first step is to track down the applicable federal or model state APA and study it carefully. Then an action or lack of action by the juvenile justice agency that could be challenged must be identified. Next, the advocate must decide whether the action is rulemaking, broadly applicable based on generalized facts, or adjudication, applicable to an individual and based on facts particular to that individual. Agencies often violate APA procedures by making decisions internally or by not fully adhering to the requirements set forth in the APA. When that occurs, these decisions can sometimes be challenged. It is important to remember that APAs govern the process of formulating and enforcing policy rather than the substance of those decisions. Nevertheless, these regulations can have input in the formulation of the policies in a juvenile institution and ensure that the policies are correctly applied to the residents. From the perspective of a juvenile advocate using APAs, the focus should be on the promulgation of rules and the application of those rules to individuals through the issuance of orders. It is in these two areas that advocates can most likely participate in or challenge agency action. Conclusion: federal and state APAs can be an effective tool for addressing unjust procedures within juvenile correction facilities. Advocates can use APAs to participate in the regulatory process and address unlawful conditions of confinement for incarcerated youth. Under the breadth of APAs, any party negatively affected by an institution's procedures may be able to challenge them through the rulemaking or adjudicatory process. The model state APA and the federal APA are effective models that should be consulted for APA construction, but advocates need to be aware of the differences. For example, jurisdictions that follow the federal APA may have fewer formal hearings than those that follow the model state APA. Readers are urged to closely examine their state statutes for differences that will affect the rights of individuals when hazardous conditions are observed. Checklist for the rulemaking process: if an agency is acting pursuant to generalized facts and is following a procedure implemented as a rule, closely examine your state statutes and the agency regulations. Determine whether the agency has followed applicable rulemaking procedures in adopting the rule. The basic rulemaking procedures under both the model state APA and the federal APA include appropriate published notice of the proposed rule, opportunity for interested parties to comment and participate in the rulemaking process, consideration of relevant material before promulgating the rule, publication of the rule at least 30 days before it becomes effective. Determine whether statutes provide more procedural protection. Participate in the rulemaking procedure if the opportunity becomes available. This can be accomplished individually or by joining forces with attorneys or advocacy groups. An agency is required to assess all relevant information it receives during the process, and the submission of data can have an effect on the final rule. Consider the validity of the final rule if it is substantially different from the proposed rule and therefore invalid under the model state APA. Checklist for the adjudicatory process: if the agency is following a procedure implemented as an adjudication, closely examine your state statutes and the agency regulations. Consider the level of hearing necessary by determining whether it is required by due process, a statute, or an agency regulation or past practice. If a hearing is required by due process rights, then weigh the juvenile's liberty interest against the government's interest in restricting that liberty interest by applying the 3 factors outlined in Matthews v. Eldridge. The nature of the interest affected, the risk the government action poses to the interest, and the likelihood that a different action would better protect that interest, the burden on the government in imposing a different action if a hearing is required by an administrative procedure statute. Then determine whether it calls for formal hearings only in on-the-record proceedings, following the federal APA, or whether it always requires formal hearing procedures, following the model state APA. Whether a hearing is formal or informal, become familiar with the hearing procedures that are required by the statute if neither due process nor a statute apply. Investigate agency regulations and past practices that may require a formal hearing and procedures. Examine each way a hearing is invoked: due process, an administrative procedure statute, or agency regulation. To determine if additional protections are available, monitor the agency to see if it is following the required procedures. Read the applicable administrative procedure statute again at each step to ensure that the juvenile is provided with all available procedural protection. Previous contents next.
Well, let's see what next has. And then I think we should give it a break. Next. self-assessment. Well, I think that I'm gonna stop the share for now and come back. Give you a break. For those who are paying attention, we started with compulsory law, as we all understand that we're citizens and we need to do better. So when you know better, you just do better. But until we meet again, this is Citizen Anderson out here, Darlene Anderson, but on Podbeam, Citizen Anderson. And I'm banned for 11 hours over there on Facebook. Obviously, they don't want me teaching. But until we meet again, c'est la vie.